Just after the Supreme Court struck down President Biden's initial effort to provide student debt relief, he reintroduced a program to cancel up to $20,000 in loans. The White House thinks this new pathway for student loan forgiveness is valid, legal, and should be able to hold up in the Supreme Court. The new effort is grounded in the Higher Education Act, unlike the first effort, which was rooted in the HEROES Act, that the administration argued they could use due to the COVID-19 national emergency. Chief Justice Roberts wrote in the court's majority opinion that the HEROES Act does not grant the authority to provide relief, and he invoked the so-called major questions doctrine, which the court uses to require that Congress give clear authorization for the executive branch to implement matters of vast economic and political significance. White House officials argue that the new route is more likely to hold up against that doctrine, but Democrats and advocates have argued that the Higher Education Act would allow the secretary to compromise, waive, or release student loans. Officials have expressed confidence in this new pathway while not making clear the full extent of why they believe this legal case can hold up in the conservative-leaning court when the other didn't. It is sure to be a target of Republicans again, despite the new justification for the program. The president also announced a 12-month on-ramp for borrowers struggling to restart their loan repayments when they resume this fall. While interest will start accruing again for borrowers in September, the action is intended to remove the threat of default or harm to credit ratings because the Education Department won't refer borrowers who miss payments to collection agencies or credit bureaus for 12 months. But the White House is again facing backlash about its decision to turn back on interest for student loans as part of its on-ramp program, which advocates argue is not enough to help struggling borrowers.